Microphone 2 check. Microphone 3 check. Microphone 4 check. Microphone 5 check. Microphone 6 check. Appellant 1. And appellee 1.
Please be seated. Good afternoon. The next and last matter on our docket, there's docket number Kennebec 25-104, Dr. Doe versus the Maine Board of Dental Practice et al. Record reflects counsel are present. We're ready to proceed. As usual, we'll be streaming this live on the internet by audio and video. At this time, I'd ask counsel to stand. Counsel will be arguing to stand. Give us your name and the party you represent. First for the appellant.
Jeffrey Edwards, Freddie Flaherty, for appellant Dr. Doe.
Good afternoon. Thank you. And for the appellee?
Good afternoon, Your Honor. Paul Suter, Assistant Attorney General, on behalf of the defendant appellees, Maine Board of Dental Practice et al., including all folks named in their official capacities and all parties named in their personal capacities except for defendant appellees Valancourt and Foster.
Thank you. All right, I guess we're ready to get underway. Attorney Edwards, we'd be happy to hear you on behalf of your client.
Thank you, Your Honor. Good afternoon, Justices of the Law Court. May it please the Court. This is an appeal that arises out of an erroneous decision by Justice Lopez in which she dismissed Dr. Doe's 1983 claims against the defendants based upon qualified immunity.
The green light is on, so can I ask, because I didn't quite understand what your argument is as to why the board members didn't have quasi-judicial immunity.
Well, first of all, Your Honor, this matter was presented to Justice Lopez on a motion to dismiss in which the only grounds asserted both in the main brief and in the reply brief were qualified immunity. There was no reference.
It's immunity, so we better look at it.
Well,
I mean, why don't they have quasi-judicial?
Well, it's a matter of compliance with Rule 7 of the Maine Rules of Civil Procedure in terms of stating the basis for your motion seeking the relief. The basis for the motion seeking the relief was qualified immunity and not absolute immunity.
We can affirm on any ground, can't we?
I don't think it was raised below.
We can affirm on any ground, even if it wasn't raised, can't we?
I don't believe so.
But why do you think we shouldn't grant quasi-judicial immunity to the board members?
Okay. Well, first of all, I would submit that the fact that the motion to dismiss was based upon qualified immunity, not absolute immunity, which is broader than qualified immunity, is to some extent a concession that the only way out for the defendants is qualified immunity. Secondly, I would argue that according to the complaint, paragraph 51, all defendants were not performing judicial or quasi-judicial functions at the time of the conduct giving rise to the plaintiff's claims. Again, since this is a 12b6 motion, a motion to dismiss rather than a motion for summary judgment, the facts alleged by the plaintiff are accepted as being accurate, true, and all reasonable inferences from the alleged facts in the complaint are accepted as true. So the factual basis for a motion to dismiss has to be anchored to what is contained in the complaint, and in this case, the complaint specifically alleges at paragraph 51 that all defendants were not performing judicial or quasi-judicial functions. So on that basis, a motion to dismiss would have to be dismissed because facially they are not entitled to judicial absolute immunity as the court has just raised as an issue.
Can I take you to the due process argument, which I think probably is the hinge pin to a lot of what you're talking about here today? And just to make sure we're on the same wavelength, we're using the four corners of the complaint.
Correct. The facts contained therein.
Yep, facts contained therein. And what happened here was the board commenced an action without a hearing, which is authorized by statute, as you know. Do we agree with that?
Statutes can authorize whatever they want, whether they're constitutional, of course.
Okay, we'll get to that. But they started under a statute, and the statute allows that, the subsection allows it to commence without a hearing if there is, in fact, a health or safety hazard, the health or safety, physical safety of a person and continued well-being is in immediate jeopardy, and provides that any suspension cannot continue for more than 30 days. haven't we already said, both we and the federal courts have said, that 30-day limitation is a savings provision that gets it under the wire for due process purposes?
I don't think it does in this case, Your Honor. I think every case stands on its own. I think, contrary to what Justice Lopez found, I think that the general rule is that when you deprive somebody of a professional license, they're entitled to a hearing prior to the deprivation unless there's some type of special circumstance that's triggered. It's an exception to a general rule. Now, obviously, we have a Maine statute that authorizes an exception, but the point of the matter is, in this particular case, that exception to the general rule requiring a pre-deprivation hearing was not triggered because of the fact that all of the complaints that were the basis for taking this action against Dr. Doe had been in place since at least April of 2017 when Defendant Valancourt went on TV.
So, Mr. Edwards,
so they waited 9 months.
Are you making an argument that Section 10,004, I think it is, which authorizes a pre-suspension, a pre-hearing suspension, are you arguing that on its face that statute is unconstitutional?
It's not unconstitutional, but in this case it was applied unconstitutionally, Your Honor, because there was no medical emergency, no risk to public safety, because all of the conduct that gave rise to the actions that the dental board took on February 15, 2017 occurred in 2015 and 2016.
Well, maybe that's a factor that
worked. They had 9
worked.
months to have an
Maybe
adjudicatory hearing.
Maybe that's a factor that worked in your client's favor. I mean, maybe the fact that the board didn't take immediate action doesn't mean that there wasn't the basis for an immediate action. It may be that the board was being deferential to your client and held off until sometime later.
I go up for
Are
a
you
lot
arguing-
of these licensing boards, and they meet 4 times a year. I mean, so it's not a matter of deference, it's a matter of getting around to it. But they had 9 months from April of 2016 till February of 2017 to have a full-blown adjudicatory hearing, which is what most boards would have done before they suspended a dental license, which is a tremendous blow to a practicing oral surgeon.
Well, arguably, I think what the board will be saying is that investigative processes are taking place, but that's another topic here. Are you arguing that the health or physical safety must relate to somebody who was at jeopardy specifically previously, and if that person no longer is in jeopardy, that particular person's in jeopardy, that it doesn't apply?
No, I'm saying that if the personal safety and health issue occurred in April of 2016, then the action to suspend, if any, should have been taken then with a full adjudicatory hearing rather than waiting 9 months.
Okay, I'm getting your argument now. But so you're saying, well, if there really was such an urgency back then, why didn't they start it then? Does that mean it's not an emergency because they started it later?
That's the whole point. It's not an emergency, a threat to safety, because they didn't move on it. You can't have it both ways.
As we know, there was a series, one might even say a cavalcade of complaints that were filed with the board. Some pretty serious stuff in there also.
Some of them were recruited, of course.
Right, yeah, for sure. But the board concluded that this was serious. And in fact, when they issued the notice, they said in their findings, if he, meaning Dr. Doe, is allowed to continue to practice in his reckless and harmful way, innocent parties are destined to continue to suffer dire consequences. So it doesn't identify particular people. It's basically the public in general. So if the risk to the public existed 17 months beforehand or afterward, that danger is still present. Maybe they were dilatory and delaying. We'll find out when the board addresses us.
I mean, in terms of the risk to the public health, the public safety, you have to balance that against Dr. Doe's constitutional right to a hearing on the merits of the basis for suspension before it's imposed. And there was clearly that opportunity in this case. There was none of the complaints that were around since April of 2016 were in the same situation in February of 2017.
But he was aware of those. He was aware of the complaints, right? Even before the order came down. He was aware of them?
I believe so.
And even after the order came down, he had 30 days to address it. But rather than addressing it 11 days later, he files an ADC appeal. which takes it off that fast track for a hearing.
Well, when the suspension was entered, the damage was done to his professional reputation. I mean, any professional lawyer, accountant, veterinarian suffering a suspension like this has the damage to their practice, damage to their professional reputation. The damage has been done. You can't put the toothpaste back in the tube by having a hearing 30 days later, 11 days later.
This is the 30-day suspension you're talking about.
The 30-day suspension. I mean, it's on the internet. It's a public record. It's out there, and it's damaging. And it resulted in, loss of hospital privileges, loss of Medicaid eligibility, many consequences.
But if he wanted a hearing, if his complaint here today is, I knew he was entitled to a hearing before they did this.
We
could have
tried to get
triggered
one
that.
before the year order. We tried to get a hearing. We asked for a hearing. We're turned down.
Okay, but after he could have requested the 30-day period hearing, by filing the ADC, he took it into a whole much, as you know, longer process, preventing him to get to a hearing on the ADC.
Well, of course, the longer process revealed that all of the claims, all the charges were groundless and were all dismissed with prejudice, which obviously underscores the need for a pre-suspension adjudication of the claims.
And this is a little bit extrajudicial. I'm just curious, it doesn't affect our decision-making here, but there's something in the record suggesting that he discontinued his dental practice and there's really nothing going on right now? Is that?
I think it's been reduced to a crawl.
Okay, I'm just, it doesn't
I think he's still,
affect.
at last, he's still practicing
Okay.
dentistry, but it's
So
severely impacted the practice.
Mr. Edwards, let me sort of broaden the focus here and ask you a big picture question. So there were 18 complaints filed, as I understand it.
Yes.
Those 18 complaints contained 64 allegations. Ultimately, 5 of those 18 complaints were pursued. 13 of them were removed to the district court. But of the 5 that were pursued at the administrative level, about half of those allegations, half of the allegations contained in the 5 complaints that were pursued were just not pursued at all. They were just dismissed. Ultimately, the board acted on just a handful of remaining allegations and adjudicated those matters in favor of your client. So in the end, your client got a really good result.
Well,
So
the damage is already done, Your Honor.
my question is, you are arguing that the process was unfair, biased against your client. How can that be true, and how can that support a 1983 action if, in fact, your client got that good result?
Well, he eventually got vindication when all of the charges and claims were dismissed, but as I said to Justice Meade, the damage was already done when he was subjected to a temporary 30-day suspension. It's on his record.
Your argument
it puts a mark on his professional reputation.
Is your argument then limited to a claim that the complaints themselves, the administrative complaint filed against your client was done improperly?
It was done improperly because he was entitled to an adjudicatory hearing before the suspension.
Anything that happened then after that period when he was entitled, when you say he was entitled to a hearing, is not really relevant to the case?
It's not. It obviously mitigated the harm, I suppose, but the point of the matter is he was suspended, it was a public record, and it was out there, and he was damaged. His practice was damaged. And
your base contention then is that the filing of the complaint, the license action against your client, was the basis for the 1983 claim, not...
The suspension on February 15, 2017 was the base, without an adjudicatory hearing to hear the evidence and decide the case on the merits.
So all of the complaints that you're making about the board's process after that point are really irrelevant?
It is, because it was too late. The damage had already been done because of the...
So what is the clearly established law that said you had to get a pre-deprivation hearing prior to the temporary suspension?
I think the case law is abundant on that, and I don't know why Justice Lopez didn't find it.
But what's your best case that says it's clearly established that when somebody says there's a public safety problem, they can't temporarily suspend before, they have to have a hearing before they suspend?
Again,
Temporary.
the general rule is that they're entitled to a adjudicatory hearing before they suffer a loss of license, unless a narrow exception would apply, which don't apply here. If you want a case citation, I'd be glad to give you one. Zinnerman v. Birch, 494 U.S. 113.
Was that a temporary suspension? That wasn't a temporary suspension of a license.
It was a It was a situation, again, I don't have the case right in front of me, I just have the site, but it does involve a situation where there was a deprivation of life, liberty, or property without an adjudicatory hearing, not subject to any exception based upon public health, public safety concerns.
Does any member of the panel wish to follow up before we move on? All right, we'll hear from you again on rebuttal. Attorney Suter would be happy to hear you on behalf of your clients.
Thank you, Justice Meade, and may it please the court. Dr. Doe's appeal suffers from a series of fundamental errors in legal reasoning. He confuses the absolute quasi-judicial immunity that applies to Section 1983 defendants as a matter of federal common law for the statutory quasi-judicial immunity that applies to Tort Claims Act cases. He overlooks the vital prerequisite that a Section 1983 claim may not be based on purported violations of state law. And most critically, he fails to appreciate the difference between the standard of review applied to the merits of a due process claim with a much more rigorous standard applied to a qualified immunity defense. To be clear, Dr. Doe has failed to allege any violations of his due process rights. But even if he had, the Superior Court properly acknowledged that the burden of demonstrating an official's actions constitute a violation of clearly established law rests with the plaintiff. And as the Superior Court concluded, Dr. Doe did not, and I quote, identify any precedent that clearly establishes that the board's temporary suspension of his license without a hearing violates due process. To the contrary, the board's alleged actions are supported by statute and case law. For these reasons, and those set forth in our brief, this court should affirm the decision of the Superior Court, and I'd be happy to answer any questions the court has.
Can I ask you at the outset, I want to direct your attention, as we have previously, to Section 1004, entitled Action Without Hearing. You're obviously well familiar with that. And subsection 3 provides that if an action is taken without a hearing, a suspension occurs, but it does not continue for more than 30 days, during which time the suspended party can seek review. That's a matter of statute, so what the board did here is they followed the statute. And the court, well, the law court and the yellow flag laws and the federal court and some other similar matters have said that's a due process savings clause, sticking in that 30-day thing, a maximum of that. Is this case analogous, for instance, to the yellow flag law, and does that 30-day suspension really save it from due process? I think due process is the hinge pin on a lot of this. Is it your argument that that subsection 3 takes it right out from under due process prohibitions?
I think it does both as a merits question, Your Honor, and then certainly it does as a matter of qualified immunity in terms of whether or not these state officials could have been on notice that their actions were violating the federal Constitution.
Well, doesn't it depend on what the reason was for the suspension? It has to be public safety, doesn't it? I mean, looking at federal law, because the state statute doesn't answer the question of when a pre-deprivation hearing is required under federal law. So under federal law, you can't just suspend a license for no reason, even temporarily, correct?
Under federal law, I believe there would need to be some sort of basis. But I would underscore the temporarily part of your question, Justice Connors, because I do think a lot of the federal case law talks about the need for a pre-deprivation hearing before a final deprivation of the property.
But if it's a short temporary and public safety has been invoked, those are the kind of considerations you look at under federal law, correct?
That's correct. I mean, if you look at the Matthews case itself, part of Justice Brennan's dissent is decrying the fact that Mr. Matthews was going to be deprived of benefits that he frankly needed to survive. And the Supreme Court stated that a post-deprivation hearing would be enough in that situation.
Subsection 3 refers to the health or physical safety of a person is the touchstone of when you can do the temporary thing here. So there is a condition that the suspension must relate to and protect the health or physical safety of a person. Does that imply that it's contemporaneous, that there is a person who is in danger and that the suspension has to protect that person, or is it broader, that it would be what happened here, as the board said, for protection of the public in general, as opposed to perhaps patients who long since may have gone outside the practice of Dr. Doe here?
I think, Justice Mead, as long as you could envision sort of the person that the action is protecting, so I wouldn't try to go so broad as to say some sort of general public safety standard. I don't know that the standard would need to be that broad, but certainly the idea of an individual patient of a physician or a dentist, if it seems to only make logical sense that if the purpose of the regulatory board is to protect public health and safety, the actions that have occurred as it relates to a prior patient must necessarily be used to protect future patients.
So,
I'm sorry. Do we then need to be concerned about the point that was made by opposing counsel, to the extent that Section 3 talks about that there's an instance of immediate jeopardy with respect to the individuals who have been potentially, whose safety is at risk? And there was this gap in this case between the imposition of the suspension and when the individuals were initially injured.
There was, but certainly there's nothing in that statute that says that the agency responsible for oversight needs to act within a certain time. I think the analogy we made in our brief was just because a bridge might be failing in January doesn't mean it's not a risk to public safety if you waited until July to fix the bridge. It's just that much more, potentially that much more urgent that
So, Mr.
action
Souter,
occur.
let me ask you about the reasons stated in the notice for the temporary suspension. And I'm looking at page 74 of the appendix. There's sort of a summary paragraph which refers to Dr. Doe's demonstrated lack of skill, but then it goes on to refer to a lack of empathy, lack of respect for his patients, lack of commitment to serving his community in a safe and caring way, which the board said was antithetical to the historical role of dentists as individuals holding a special position of trust within society. Setting aside the lack of skill, I think that that goes more to the immediate jeopardy standard. But how do all those other factors, lack of empathy, respect for patients, how does that sort of advance the cause or advance the principle, advance the conclusion that there's immediate jeopardy? That just sounds very sort of squishy.
I certainly take your point that those particular citations might not address health and safety, but I don't think the question here is, the point isn't to drill down on any individual statement. The question is whether the vote to temporarily suspend his license was, first of all, a violation of the federal Constitution, and then second, whether it was a clearly established violation. And so I believe the case law states that even if they're getting it wrong, which certainly we would argue the board did not get it wrong here, but even if they were getting it wrong, that's not the question. The question is whether the plaintiff can point to some sort of clearly established case law that says, look at this pattern of facts. Any reasonable person reading this case would know that their actions here are violating the Constitution. I believe the words that the Supreme Court uses is that it puts it beyond debate. And I actually think the back and forth in our briefs only underscores that at best there is a debate about whether a constitutional right was violated, not whether that was clearly established.
And on that point, Mr. Souter, if you can help me understand a legal point which relates to the basis for a 1983 claim. There are a couple of different propositions or assertions that are found like everywhere in any 1983 case. One of those assertions is that the failure to comply with state law cannot support a 1983 claim. But then there is also a series of statements that you find, again, everywhere in any 1983 case, which says that the right that's violated in order to support a 1983 claim is either a statutory right or a constitutional right. So on the one hand, the case law precludes a violation of state law as giving rise to a 1983 claim, but then there's another sort of line of analysis which suggests that a statutory violation does support a 1983 claim. So can you help me find the nuance to reconcile those two?
My understanding, Justice Yelm, is that originally Section 1983 protected federal constitutional rights, and I believe fairly early on in the process, it was amended to protect certain federal statutory rights. And so it could be that there is a federal statutory right that a plaintiff has that could be violated, that it serves as the basis of a Section 1983 action, but a state constitutional or state statutory right cannot be the basis of a 1983 action. I do think that to the extent, for example, that Maine's Constitution adopts a lot of the same principles as the federal Constitution, I suppose if there is evidence of a violation that would be analogous, that might be used as evidence for the federal 1983 claim, but a violation of a state statute or state constitutional right cannot be the basis of the 1983
And the
claim.
state statute might create the property interest that is protected under the Constitution. But other than that, we have to look at federal law. And the case law cited by the plaintiffs really relate to final hearings, don't they, for final and not temporary suspensions?
That's correct, Your Honor, and that's precisely what happened here. The license was temporarily suspended. A final hearing was scheduled. There is evidence in the record that even from what was attached to the complaint that much of that delay was a scheduling delay. The board at various points in time were trying to schedule the hearing even on Sundays during that 30-day period. But ultimately, a hearing was held, a final hearing was held, before any final deprivation of the license, and so...
Well, the temporary suspension was itself suspended after 30 days, right?
That's correct, and to some points that were being made earlier, to the extent that Dr. Doe is frustrated with the temporary suspension, there is a process to reverse that. It's the ADC process, and the ADC process was moving forward in this case when Dr. Doe opted to dismiss his ADC petition in favor of just more quickly appealing the 1983 damages action.
So what about the quasi-judicial? That wouldn't apply to the investigatory staff, would it?
I think it would, Your Honor. There is case law that implies that certain aspects of investigation could potentially go into a quasi-judicial analysis, or to the extent that the investigation is more prosecutorial in nature, I believe there is sufficiently analogous prosecutorial immunity that applies to Section 1983.
Can I ask you, if we accept plaintiff's due process argument that a violation took place, one of the aspects of relief that's being requested here is injunctive relief, where we would order the state not to further discipline or bring actions against him. Your take on that?
So I believe, Your Honor, that has not been preserved, at least in the appellate briefing, but certainly our position is that is not available for various immunity-based reasons, injunctive relief needing to be prospective in order to prevent a certain or nearly certain constitutional violation, and there's a series of case law in Lyons versus Los Angeles that comes out of, which wouldn't be applicable to Dr. Doe's situation because there is no certain or nearly certain constitutional violation in the future.
And one other question. Plaintiff asserts that the executive director here was biased against him, and that bias lapped over into other members of the board and the rest of it. This is a motion to dismiss, so we look at the complaint. The complaint says she was biased, and she put this bias onto other decision makers there. Are we bound by that conclusory statement? And if that's the case, wouldn't that be the basis? Would that still be the basis would there be a basis to dismiss the complaint?
So I think that is a sort of a two-part answer. In terms of the bias allegation. I think whether or not someone is biased is a question of law that is based on the factual allegations about the bias. And so that is, I believe, where the court would start, similar to whether public health or safety was at issue in the allegations related to that aspect of the matter. But beyond that, the allegations of bias regarding the executive director would still need to be connected to some sort of clearly established due process violation. And the executive director was not alleged to have been a decision maker. She was not alleged to have voted on the temporary suspension, nor was the hearing officer who was originally assigned to the case was not someone who voted on the temporary suspension. And so, no, I don't believe those would be the basis of a due process claim going forward.
Further questions from the panel? You have 8 seconds. in case
I will
make a
gladly take
concluding
those 8
statement.
seconds. Thank you, Your Honor.
Thank you. Attorney Edwards, would be happy to hear you in rebuttal.
And point of clarification, following up on that last point, the bias claim is primarily against the dental board itself as an institution in terms of its obligation to be fair, just, and impartial in its decision-making.
Is it enough just to say the board was biased, or do we need something else
I
in the
mean, I think
complaint?
that's a conclusion, I agree, but the record, the complaint, the second amended complaint contains all kinds of detail about what happened prior to February 15, 2016 to result in the temporary suspension of Dr. Doe's dental license. And, you know, from that, it looks like the executive director had numerous ex parte communications with board members off the record.
Well, you say ex parte communicate. The statute does say that the board members, the people within the board, can talk to each other. They can't talk to the public about it, but there's no prohibition against them talking about it amongst themselves.
I mean, again, you know, the board is claiming to be a judicial body, but they're not acting judicially in the sense of engaging in ex parte off-the-record communications with somebody who's investigating and prosecuting complaints against Dr. Doe. Again, whether this is called a temporary suspension or a final suspension, the damage was done as far as Dr. Doe was concerned, because it was out there and it damaged his reputation and damaged his career. And with respect to the yellow flag case, I assume the court's referring to the In re J case.
Yes.
That is completely distinguishable from this case because of the fact that it permitted taking away of a right to carry a firearm without a hearing in a situation where there was a procedure set in place whereby there had to be some type of medical provider provide a letter or an affidavit given to the judge, who would then enter an order taking away the right to carry the firearm. So there were safeguards put in place against an erroneous decision. Thank you.
Thank you. All right, that concludes the argument. We thank the attorneys for the brief argument submitted to us today. We'll take the matter under advisement, issue a decision in due course, and clerk will close court for the session.
All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court of the Law Court may hence depart, give their attendance here at the call of the Chief Justice, as this court now stands adjourned. God save the state of Maine and this